Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Ar-Rahmanir-Rahim. Maliki Yawmiddin. Iyaka na'budu wa iyaka nasta'een. Ihdina siratal mustaqim. Siratal ladina an'amta alayhim. Ghayr maghdubi alayhim. Wala dwalin. Alhamdulillah. Dr. Sonata Kamara, co-founder of Temple Mother Earth, sending love, peace, and abundance prayer to everyone around the world.
Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids.
Welcome to Magnets, Crystals, and Pyramids. Success is your destiny.
Welcome everyone. Peace. Welcome to Moorish Monday with Abdullah El Tlemosi Bey. We have a good one for you tonight. Mastering due process, controlling through structure. Mastering due process, controlling the case through structure. So let people know that we're on live and direct. My website, mooresandmasonry.org. We'll be strolling across the stream for the next 2 hours. Our guests, we have King Al Bey. We also have Rahim Allah Bey, Ambassador Rahim Allah Bey. So we're gonna King, we'll get right to it. We're gonna put the flyer up of our upcoming event on May 16th. The scheduled May 16th event. Rahim will read the flyer.
Okay, give me a second. I'm trying.
And then after that, you'll switch over. Now, we're gonna do is we're not gonna wait till the end for y'all to ask for me to fill questions. So what you do throughout we're gonna stop. Type your questions in the chat as you're listening, and then I'll stop periodically to look at any questions and comments so that we can have ongoing engagement.
Okay, hold on. Let me present.
You share, present. So welcome everyone. Mastering due process.
So I put it in there.
All right, we have the flyer up here. Go ahead, Rahim.
All right, Islam. And good evening to everyone. I'd like to send my honors and many praises to Allah, Prophet Noble Ali. Gratitude and honor to the brother Hank and Magnet Crystal Pyramid, Ambassador, brother Abdullah El Talib Mosley Bey, and brother King El Bey, everyone that has joined us this evening. To get everyone up to speed, meeting of the Mod Civic Association and Louisa Flores presents Civic Education Lecture Series with King El Bey. In this lecture series, we'll be learning legal tools to protect and safeguard our community. And the things that we'll be learning, as I read this flyer, is learn due process to handle legal cases. Learn how to address prosecutorial and police misconduct. Why you should know the rules of the court. What is the role of the prosecutor and judge, and how to read statutes. This event, it will be May 16th, 2026. The doors will open at 11:30 a.m. Eastern Standard Time. The address is 122-13 Gower Brewer Boulevard, Jamaica, New York, 11436. You will contact myself, Ambassador Rahim Allah Bey, founder and president of Meeting of the Mod Civic Association. My cell phone number is 347-8 347-832-9875. Again, 347-832-9875. My email address is rab.great, GREAT, seal, SEAL, the number 7, at gmail.com. Again, rab.greatseal7 at gmail.com. Meetings of the Mind Civic Association, I just want to let you know about our mission statement is to provide civic education to the New York and North Jersey areas in the studies of nationality, consanguinity, ancestry, genealogy, parentage, lineage, descent, pedigree, and legal bond to and protection of a nation state, human rights, civil polity, political polity, jurisprudence, legal philosophy and legal principles, law of nations, etymology, which is the study of the history, origin, and true meaning of words, semantics, which is the study of the change of meaning of words. Now I would like to move forward and read our plan of action. We gather not just to talk about problems, but to present solutions. Our plan of action is rooted in one fundamental principle. Knowledge of the law is power. And when that knowledge is shared collectively, it becomes protection. Our objective Our objective is clear: to create civic and educational pathways that improve the political, economic, and social conditions for our communities. We aim to do this by teaching our people the legal tools necessary to prevent and challenge discriminatory practices, including due process violations, prosecutorial misconduct, judicial misconduct, police misconduct, unethical agency practices. These are not abstract issues. These are real challenges affecting real families, real futures, and real communities. Moving forward from reaction to prevention. For too long, many of our communities have been placed in a reactionary position, responding only after harm has occurred. Our plan shifts that paradigm. We move from a reactionary approach to a preventive strategic approach. Instead of asking, what do we do now that the damage is done, we ask, how do we prevent the damage in the first place? Education is the foundation of prevention. When communities understand their constitutional protections, their procedural rights, complaint mechanisms, oversight bodies, administrative remedies, legislative channels, they become less vulnerable and more empowered. Preventive measures. Our initiative focuses on preventive measures designed to de-escalate volatile encounters, deter discriminatory action, diminish systemic targeting, solve prejudicial situations before they escalate. We educate our people on how to properly document incidents, file complaints with the appropriate local, state, and federal agencies, pursue civil remedies and lawsuits where necessary, engage legislative representatives, and advocate for policy reform. This is not about confrontation, it's about lawful strategic engagement. It is about understanding the system well enough to navigate it effectively. Stopping the corrosion. Unchecked misconduct corrodes trust. Unchecked discrimination corrodes opportunity. Unchecked targeting corrodes entire communities. Our mission is to stop that corrosion. We do that not through rhetoric, but through structure, through education, through lawful action, and through organized civic engagement. Pathways to remedy and resolution. Every problem must have a pathway to remedy. We are building pathways to, we are building clear pathways to administrative resolution, judicial remedies, legislative reform, community accountability, policy transformation. We are building a culture where our communities know where to go, what to file, who to contact, what timelines apply, and what standards must be met. And most importantly, we build a culture where our people understand their rights before those rights are violated. In closing, this is about safeguarding our communities. This is about strengthening civic literacy. This is about transforming vulnerability into preparedness. When we teach legal tools, we build protection. When we build protection, we build stability. When we build stability, we build power. This is our plan of action. Legal tools, civic education, preventive measures, pathways to remedy and resolution. When unity and knowledge comes together, it becomes an unstoppable force. Gratitude, peace, love, and light.
All right.
Okay, hold on.
All right. So Ken, you gonna bring up the
I'm trying to get back. Let me see what happened.
yes. So
All right.
as King did brings up the next screen
Let me see.
of the PowerPoint.
I think this one there.
So once again, we have the flyer up here, learning legal tools to protect and safeguard our community. Want to see y'all in the house on May 16th. Let people know that we're on. Share this post. Shout out to Ambassador Trinity Davis Floyd, Ambassador Latonya Davis.
Congratulations.
Yes.
Can you see this, Abdullah?
Let me go back. Let me see. Not yet.
It says sharing.
So it's sharing, but hasn't. It hasn't.
Stop sharing. Let me. I don't know why that. Share screen.
Share screen. Yes.
I'm gonna go to Windows. Okay. Let's share. Can you see it?
Not yet.
I don't know why it's not sharing. It's down here, so
You see it down there.
it says stop screen is on there.
Not. You had the flyer up there. So this. I mean, you know how to do it because you done it
I'm
before.
I've done it.
Yeah. Try it again.
Let me see.
Share screen.
I'll go to Windows, Microsoft tab. I hit the Windows. I click on Windows and I hit share. It's saying it's sharing Windows.
Mm.
I don't know why it's not sharing. It's in. I see it in the box, but it's not coming up on screen. Let's see. Mm-hmm.
Brother Hank.
I don't know why it's not sharing the screen. Okay, let me. I don't know why it's
I don't know what's because you had it up there.
I just
But
shared the what's your name it. It didn't do nothing then. I just shared that.
all right. So, wants to welcome everyone.
Let me
We're
see.
going to getting the PowerPoints on the screen.
Okay, share image. It's file. Nope, that's file. It won't.
You hear me, brother Hank? So the way we can. I know, because I don't know what to do.
It's let me. It say Windows, and then so I click onto Windows. And I'm clicking on to that. Let me see if, and then I hit share. Can you see it?
Yeah, you'll be able to see it too.
It pops up on my side where it's showing that it's being shared.
Um, I guess we're gonna just have to. You have to just read from the screen then.
I don't know why it's not. It says stop screen. I don't know why it's not sharing. Ugh, hold on, let me go in and out. Let me come. Could I go in and out? You think that'll let me do it?
I don't know. I can't answer that, brother.
Try it and see what happens.
Would Brother Hank be able to let me in if I leave?
I gotta call him.
He
I
just
have
let
to
me.
go out.
He just let me back in. So
Yeah,
probably
go out then.
just
Okay. All right.
Let's
I'm
see
up.
how we can do this. All right.
if anything, I'll call him.
All right. All right. So yes, we're waiting. So King went out so that he can see we can if that will work, and he'll be able to share the screen. He has a PowerPoint presentation prepared, so we're just trying to get that going. All right. Let us know that you're here. Give us a wave, a thumbs up, a welcome. Those who are on, give us a shout out. All right, so King. All right, so he's back. So let's just give it another try. Right. I think it should. This should work because you were able to do the flyer.
Let me share screen. Go to Windows. Can you see it now?
Not yet. Because
I see.
you were able to do. Oh, here we go. That worked. Going back out worked because you were able to do it. Thank you. All right, here we go. Yes, the master lecture explained version. All right, so King, you got the floor.
Okay, give me 1 second. I got it. This is my mom. Let me give me
Are you gonna have to go off? You got to. I'm going to his phone. All right, y'all. So we waiting for King as we wait. Welcome everyone. Let people know that we're live. Brother Jamie, peace, brother. Looking forward to seeing you on May 16th. Um, in the house at Jamaica, Queens.
I'm
We'll,
back.
we'll be arriving on May 15th. King will be arriving in town on May 15th, and I'll be in town on May 15th too, the day before. All right, all right, King, you have the floor.
Okay, so I'm going back. Okay, mastering lecture. Mastering due process, controlling the case through law and structure. So, what is due process? Due process, I'm going to give you a better explanation. It's a requisite. A requisite is a required task. So, due process acts like a lock and key. In order for you to have access to the court, you must check a box of several things before you can enter the courtroom. You must give notice, right? You must have an informed notice of what's going on. You got to know the time and the place of the hearing. You got to be very informative. You have a right to be heard. You have a right to present evidence. You have a right to call witnesses. You have a right to uh, to be in front of a fair tribunal. You have a right, if it's criminal, to a jury trial. You have a lot of different rights. Due process takes shape in a lot of different ways. So the court got to allow these things. And if they fail to give you this, right, they lock themselves out. So on the other end, on a civil end, if you were bringing a case, you have to perform some of the similar actions. Got to give notice. You got to give notice of the hearing. You can ask the court to send off the notice. You can have a right to present your evidence. You have a right to present your claim, affidavits, witnesses, testimony, all of these different things, the right to be heard. These are different things that you must be aware of and how to have your case be treated fairly. The court don't supposed to interrupt you if the judge is interrupting you and cutting you off. in the middle of your saying things, if the court is doing those kind of things and interrupting and giving favor to the prosecutor by not allowing you to speak. These are all procedural substantive due process that you can raise. So the question is, when we're dealing with due process of the Fifth and 14th Amendment, you must understand due process come in two forms: procedural due process and substantive. So procedural deal with the rules, the procedures that involve. And then under the common law, you have certain due process, procedural due process, like a right to be heard, a right to call witnesses. These are all constitutional protected, a right to a speedy trial, a right to be judged by peers. All of those things are protected. Then you have your fundamental rights that's also protected, right? The question is, did the court encroach upon a right that's protected? And then if the right is protected, did they go about doing everything accordingly? Did they infringe upon a right that they didn't have a right to do? Um, and these can shape in all types of ways, interfering with your rights as a parent, trying to tell you what school your kids can go to, your right to marriage, who trying to dictate who you can marry, trying to dictate what religion you perform. Like say if you was in, let's say you was going, give an example, they said, well, we need some DNA evidence. Let's say for child support, it's not a crime. You can deny that because that can go against your religious rights. Your religion say you can't practice that. These are things that can be identified. So I'm giving you some examples, but you have to understand substantive, because a lot of people miss the mark on substantive due process. They don't really understand that. A lot of people will get procedural, following the rules of procedure, criminal rules of procedure, civil rules of procedure, rules of evidence, rules of superintendent. In some states, it could be something different. Local rules of the court, appellant rules, Supreme Court rules, um, all of these things you have to know how to do, and they are very favorable for those who choose to ignore those. Even the state, if the state choose to ignore the rules and act, hazardly, the rules are very unforgiving. So they can bar you from having any attempt. Even if the state try to, if they break a rule, sometimes it's a dagger to the heart if you know how to deal with the court, to know how to have the proper tools like injunctions, getting injunction relief, filing proper motions, right? With this, having the court to do this, filing a motion to reconsider these violations, like when they spoilage of evidence, and when you ask for Brady discovery, you have a right to discovery of everything, right? No, is it? So you have a right to these components, but you must understand what due process is. You must read enough case law to identify what is due process so that you don't have to worry about due process. So you need to understand what this look like and what it's shaped. So we got all of these things have to be traceable. So if you have a hearing schedule, you never receive notice, the court proceeds anyway, a judgment is entered against you, that can violate your procedural due process. Give me 1 second. 1 second.
You want to start the exercise, King?
Yeah. Yeah. Would people want to ask questions?
No, you want not. There are any questions yet. Just start the uh, the PowerPoint, the presentation. You gave an introduction.
Okay.
So applying
The
the legal formula.
okay. So the philosophy, right? So what is the philosophy of understanding law? So before a law was ever created, there's a mindset behind the intended purpose of understanding that. So the framers of law, from Aristotle and the greater our ancient ancestors, Moors, who created these great civilizations, they observed life and they wanted to see rights that was given. Everyone has a right to childbirth. Everyone. They seen that that was a natural occurrence, right? Nobody gave you that. That was something that was God given or rights that were universal across the board. So when we talk about philosophy of law, we looking at what what was the thinking process when they shape a particular principle or rule. Once you shape the ideology, then they create the law. That law is embedded with a particular principles, right? Those principles create the law. They're embedded in the law, and those principles are made up of elements. And those elements, you should, anytime you are charged with something, you should be able to see those elements. The court got to meet those elements of that principle, or they don't have a claim. They haven't perfected it, a claim, because they have to meet all the necessary elements of that statute or that particular law, even if it's judge made law under the common law. All the elements got to exist or they haven't perfected a claim. And now you can move to ask the court to dismiss this on the grounds to fail to state a claim where relief can be granted due to the following reasons: that the state has not proven or other party has not proven the elements necessary to perfect the action against the defendant, and so which the defendant is requesting that the court to dismiss this with or without prejudice on the grounds that the party had ample time to perfect this claim and should have had all of the available resources necessary to bring such claim forward. And you asking the court to dismiss it with or without prejudice on particular grounds. And you could cite case law that supports your position or affidavits that, along with case law, to show that you have the supporting evidence with the exhibits to show that you met the threshold of this case law under the preponderance of evidence to have this case dismissed with prejudice if you have the supporting case law, Supreme Court case law, or either any state court case law. So you got to understand this. So when we talk about applying the formula, we're looking at the fairness, the right to notice under this situation where we're talking about you didn't get a notice, right? Where it says you have not received a scenario, you have a hearing scheduled, you never received a notice. The court proceeding proceeds anyway. A judge is entered a judgment is entered against you. So the philosophy would be the fairness that was in there and the fairness that the court has to. They're rooted in fairness. And fail to give you notice would violate the philosophy of fairness. And then what is the elements? Fail to give notice of a hearing, time to prepare, opportunity to respond. Evidence: no mail notice, no email notice, and no signed receipt. So they don't have anything that support that they sent it to the correct address, or you can show that. Defendant did not receive notice. So that's a fact. And what do the law under these circumstances? What did the law conclude? The law said, hey, since due process is violated, the judgment can be vacated. So when you understand how to perform this formula, you can understand how to look at your case and understand did they meet the elements, the philosophy behind the statute, if they violated a common law, because this falls under the common law, failure to give notice, right? Let me go back. Failure to give notice, right? This would That's a common law practice, and that falls under fairness, and that will violate the philosophy of fairness. So let's go to a situation. It says the law says anyone accused is automatically guilty. So, giving you another substantive due process right scenario. So, no presumption of innocence. It deny you the right of innocence, and it give you no right to the court access to a hearing, making this itself unconstitutional due to the fact that it didn't follow the constitutional principle of fairness and due process. Due process, once again, is a requisite. It's required. It's a requirement for any party trying to get access to the court. So when we look at the prosecutor's office and the state attorney general, they supposed to be separate from the court. The court supposed to evolve, sits on its own axis. The prosecutor, even though he is an official of the court, right? He still have to have the same, you and him are is on equal footing to access to the court. He cannot break the law to enforce the law. He do not have any special privilege to get into the court. Without him understanding these rules, if he failed to adhere to any of these principles, everything he done was in vain and it can be violated. And they're acting in bad faith, and the court and the judge allow this. They have abused their discretion, and they understand they don't have the discretion to do so, and that will violate due process. No judge can have the right to uh, abuse due process. They don't have the discretion to say we have the right to override due process. No judge. So when they violate due process altogether, then that judgment or whatever could be vacated, and you can ask even if that judge be recused because they allowed the abuse to happen. They supported the abuse, and it was unlawful in itself, making it unconstitutional, and which every judge took an oath to uphold. So these are things that you have to be able to recognize and know. Using using due process to handle cases. So you don't argue opinions, you audit the process, step by step method. Did I receive proper notice? Did I have a fair chance to present my case? Was the decision maker neutral? These are things that you have to ask yourself when you're dealing with these cases. You got to understand the right to be heard, the right to be in front of a neutral tribunal, a right to present evidence, a right to a speedy trial. So, one of the things that tends to happen when a violation of due process tend to hit, it then makes a domino effect on all the others, substantives and procedural. They tend to overlap a lot of times, but if you don't know how to identify them, the course is not going to tell you how to identify them. And if you got a lawyer and he's not arguing these certain things, this can leave you in limbo. Because sometimes you got to remember, this is a business before it's a court. Why do I say that? I took accounting when I was in college. And the first rule of accounting is if you I don't care what business you hold. If it don't make no money, it won't be a business very long. So we have to understand some of these things, motivating factors when dealing with the court. It precipitates to getting the money. Judges would do certain things that is should be scrutinized with a sharp eye. And if you don't know how to go about doing that, you can find yourself in a situation where your case, where you can be in jail and be innocent. And it happens out to us in our community all the time due to the fact we don't have the legal tools to be able to identify, isolate these issues, and deal with these on a more profound manner. And once we teach the community, we set up enough information, have enough people to know this information, to watch for these things, to be able to address it in abundance, with abundance of people who know what's going on versus one individual. So when you're looking at this information and you understand it, this is this is a game changer. So when understanding how to apply this legal formula, a legal method to understand law, I wrote a book. I got several books coming. These books is going to help you understand how to critically think and examine what you need to do. Why am I talking like this? Because this is the operation of law. Without understanding how the law operates, not understanding the application of law, and understanding the source behind that gives this law force, that support it, from constitutional to administratively, all the way to statutory law, to congressional law, as we may put, which is statutory laws, congressional law, or state law from the General Assembly, right? We got to understand how the law came about and look at the context of the law by reading the law itself in the manuscripts, looking at the minutes of the statutes that was created, understanding how it was voted into office and its intent and purpose of the law. A lot of us do not read that, and a lot of times the law get overlooked. We don't know how to constitutionally challenge this, or we don't raise issues at all. And now we find ourselves in limbo because we didn't raise these issues, and the court don't let you get a second bite at the apple. So we're going to talk about the formula again. You must understand the philosophy to understand the principle, to identify the elements, to identify, once you identify the the elements, you must use the evidence standards of practice, the evidentiary standards of practice to understand the rules of evidence by using the rules of evidence to identify the violations and the elements that exist or the elements that don't exist, either or, uh, and understanding that now these things can, based on affidavits and other how you present it, now it's factual based on your affidavits and exhibits that support the reason why you filed a motion to dismiss or whatever, giving you good cause shown and grounds for such action. And once the law has already concluded, once due process has been violated, it's pretty much, it's irreversible. So,
Anyone have any questions? Type your questions in or comment. Any questions? Comments? Type it in the chat. Type your questions in. Any or comments?
giving people a chance to really,
Right.
you know,
Question or comments?
give them a chance to let this stuff register because it can get, you know, am I making sense to everyone out there?
Any thumbs? Guess we get some thumbs up. Questions, comments.
I'm trying to make this simplified so everyone can adjust to this information because there's a lot of misconception about the law, about properly using affidavits as they stand of truth and they're not can be rebutted. That's false. We don't file motions. That's false. Um, we only use writs. That's false. Um, you got to understand how to use that. So, like for example, most of us they'll use a writ, a constitutional writ, a writ of habeas. The court can accept it, but they have a statutory writ. So, for that state court, most of the time when you file a writ of habeas corpus under the common law, you can use it in the state action. Um, but a lot of times they will convert it over into a statutory habeas because the state is uniform with the state laws and they have to abide by that. They have to abide by the common law too. So just to let you guys know, so the common law, the Supreme Court deals with most of your common law issues. They address them personally. Uh, you have to look at that and understand the separation between the two, looking at the civil law versus the common law and how that is works within the states and outside the state. So, understanding how to look at these statutes and read them. Anyone got any questions? Nobody is saying nothing, Abdullah.
I see. Give me 1 minute. Uh,
I can't see nothing.
got thumbs up.
Someone
What?
asked, what do you mean about common law? What do you mean by common law?
Common law is judgment law. So we're following the laws of England. We're under the common law of England. So based on their English traditions and laws, right? They had a set of laws that and traditions that go all the way back that now can be applied. So even like I have looked up case law from England and utilized that. For example, a McKinsey friend. What is a McKinsey friend? That's somebody who can speak, especially in a civil case, under England common law. I took and put that into that with the case law to act as a McKinsey friend.
Yeah, pardon, that was Trinity that asked that question. I just wanted to give up.
Yeah, so when we talk about common law, it's normally judge-made law. Judges make decisions, and those judge-made laws, a lot of times Supreme Court make a lot of those common law issues because they address them most of the time. When you go into the Supreme Court, they stay within the jurisdiction of the common law, and they look at the civil law and see if the civil law, the statute, and break any type of uh, constitutional law principle, right? And any common law principle. They look at the statute to determine if they're in violation of something, especially a fundamental right that's a protected right that the government said they will protect. And they only can have grounds, certain particular grounds, to not protect those civil liberties or some of those common law protections, those rights. They only can violate that if it would only stream the circumstances, and they will have to show cause why. And that's not with everything. That's in particular certain situations. Just like COVID, you have a right to travel and go outside and stuff like that, even if you had a valid driver's license. But remember, they put us on curfew. You had to be at the house and you couldn't do this due to the fact they claimed a state of emergency based on COVID. And they was able to shut down the city, and people was, if you was out there, you was getting tickets or getting arrested. I remember that when that COVID, at one point, that's how serious they had COVID, because they were saying we don't want the spread of COVID. These are things that we have to understand that they can use to manipulate. So we have to be understanding and understand the law to be able to understand what our rights is, and that's why we got to come together and stop individually doing things and unite as a force. It should we at a point where it should be no more individual nothing. It should only be support groups, organizations working as a unified front. Period. Nothing else. You're going to lose most of the time, especially if you don't have King Elbey and Brother Abdul or Brother Rahim and Brother Israel. You're really going to have some problems. There's a lot of smoke and fire going to be in the courtroom. So I'm just letting y'all know this can get real serious. So let me continue.
You can continue. We had I said just if you got any questions or comments, type them in, put them in the chat.
So I go over traceable parts. Okay, so it says, judge says, I already know how I'm ruling before the hearing anything. Problem, judge is not neutral, right? If the judge say, I already know how I'm ruling before hearing anything, is he being neutral? He's being biased. Judge is not neutral. Conclusion, automatically due process violation. But if you don't understand that and you don't raise this issue, guess what's going to happen? If you don't raise it on appeal and you don't object, if you don't preserve your right to object, the judge deny you of a right to be heard to object, what do? That's the problem. What do you do next? Do you know what to file? Do you file an injunction? Do you file a motion to reconsider? These are things that you need to do. You must create it for the records, because the appeal court is nothing but courts of records. When you're dealing with the Supreme Court after you've been in the state court, you are acting as a court of record. You're not going into a common law court dealing with the Supreme Court, because the Supreme Court, when you're dealing with common law, most of your common law actions, the Supreme Court has original jurisdiction. You got to understand that. So even if your case starts in the state court and it gets to the Supreme Court of the United States, they acting as an appellate court, unless under original action.
Hey Ken, let me say something. What I was just thinking, what you are by teaching the due process, the way you're doing it so thoroughly, you are in essence making it be known that they're not acting for the judge, because you had the example you mentioned about going back to that example about the judge say I don't have to, and go back to that.
I'll go back.
The judge already decided.
Yeah,
right. Let's go
now. How I'm ruling before hearing anything.
All right. So now the judge already knows that that's a violation. The judge knows that. The judge knows that. That you you're not educating the judge. The judge already knows that. So would be a violation of his oath of the Constitution. Like the judge is deliberately, because that would be a deliberate act. That's a deliberate act of abuse.
Right.
So by teaching due process so thoroughly, you pretty much will be exposing this massive abuse constitutional authority. Am I hitting the nail on the head?
Yeah, yeah. Because if you don't know what due process look like, if you don't see due process wears a dress. It's like a pretty woman. When she walks in a room, she's really identifiable, right? If you don't know what she look like when she walk in a room and you like, who is this woman, right? You don't know she's there to help you and she's walking over there to you and you tell her to get away, right? You wave her off, right? Waive your due process rights because you don't understand what they are and how to identify them. Guess what happened? She walks out the room and she said, I was in there to help King Bay, but he waved me off. He told me he didn't need me. He didn't know who I was, right? So now she's gone because you didn't understand what to identify and what to look for. You have to understand these things. That's why I said I read a lot of case law, but I put a lot of things into practice. I put a lot of things into shaping what I need to address with the court to look at biasness, double-mindedness of the judge. The judge say one thing and then do another. The judge is being double-minded, making himself biased, and I'm asking the judge to recuse himself now because he's putting everyone at jeopardy. Why I say he putting everybody at jeopardy? Because this is time and money. I don't have time to be retried on a case that he's being biased against. I don't have that kind of time. And you address that in your appeal. And you let the appealing court that this is waste of my time. This is a waste of your time is a fundamental right. See, a lot of people don't know that. See, that's a fundamental right. The court don't have the right to waste your time, to drag you in the courtroom and make deliberate acts and waste your time because that pulls you away from your job, your children, and money. You can ask the court that these violated my ability to work as a fundamental practice, my ability to take care of my kids as a fundamental practice, ability to come in here and take away time that I could be doing other things that is what beneficial to me, my friends, and family. That's a violation of a fundamental right. But if you don't understand how to address it and dress her up real good and show these facts and break it down to a higher court who has the authority to examine this, to look at this with a thorough eye, because you're very articulate enough to express these abuses, these errors, and because the appellate court only look for errors. And we'll get into all the variations of different errors. That's another time, because now you're dealing with the variations of errors. You know what I'm saying? So I just give you a couple of them: constitutional errors, plain error, right? Then they have one called harmless error, where the error was an error, but it was harmless. It didn't affect the outcome of the case. So they won't overturn that. But I'm just giving y'all some. I'm not going to go over. It's about 8 to 10 of them. 513-301-4352+1. So, hold on. Put my phone on mute.
As I said, if there are any questions, or if you have any questions or comments, put them in the chat. Something you don't understand, a point that you don't understand, or a point that you want King to expound on.
I have one I want him to expound on, because a lot of people deal with this issue when they go to court thinking that they can't speak or because they have an attorney. So you could touch on the opportunity to be heard and the right to be heard.
Okay,
right before. Mm-hmm.
So your attorney worked for you, right? So a lot of times you have to. So I see people do this all the time. The attorney be speaking for them, right? The attorney only is ineffective as counsel if it's addressed and identified the effectiveness of counsel, right? So a lot of people won't raise that issue at trial and they'll raise it on appeal and it's too late. So when an attorney represents you and he's doing stuff that you know he's supposed to be doing, you bring it up before the judge. And if the judge don't allow you to be heard, that's something that you can file an injunction or you can say for an appeal. But you want to make sure you raise that issue. And if the judge is denying you a right to be heard, you have to make sure you mention it to a record or you file a motion for a right to be heard and see if the motion to be denied and you put it all in the motion. See, the things that we have to do, you have to be very thorough because these are when you go to the appellate court and the Supreme Court under these types of appellate situations, because the Supreme Court is going to act as an appellate court. These are courts of record. So they're only going to look at the record. They're not going to allow you to raise issues that wasn't addressed before the lower court. So you have to be very thorough in your presentation and don't skip a beat. You must cover, you must turn over every rock. You understand what I'm saying? So when we're dealing with these issues, you have to deal with these matters very thoroughly, very articulately. You have to be very forthcoming, knowing everything that you need to know so that you can bring it up. This is why I had so much success because I was just all over it. I litigated a lot. I did a lot of doing that, bringing information to the table, and I was just very thorough. Very, very, very thorough. I'm talking about thorough, thorough, thorough. I studied my butt off. I don't remember half of the case law that I done read. I done read so much case law, but I wasn't worried about understanding the case law itself. I was looking at the principles. I looked at how to utilize these tools, motions, affidavits with exhibits. I was not even most attorneys don't even do it like that. They normally file a motion. Don't It's not supported by affidavit. They might have an affidavit, but I'm very when you look at my things, and if you look at the local rules, their number, like most people, like some attorneys or some prosecutors have filed stuff and they're not in scope of the local rules. And you can challenge that. The Court of Appeals might say, oh, that's harmless error. But you can say, well, how's it harmless when the court is scrutinizing me on the same thing, right? Kearns versus Turner. The court cannot scrutinize a pro se litigant as the same as an attorney. We must understand these things. You've got the case law to support it. You must understand how to articulate what you're trying to drive your points home. So when I'm dealing with case law, I'm just very, very thorough. I'm just very, I'm very thorough. And that's how you have to be. I did it for 17 years. I'm in teaching mode so that I can replicate this process by teaching people so they can have the eyes to identify this. So it can be 100,000 King L Bays across the nation so that we can work in unison to to affect change, to promote growth and development in our communities by stopping this erosion and breakdown due to these unlawful injustice. Because a lot of our people get incarcerated and find out years later they get exonerated because they were prosecuted illegally. Due process is violated, and then most of them don't even get a reward, don't even get money because they didn't sign documents, and that should be unconstitutional. That the state will have you sign something for your release so that you can't sue. Sometimes they do a lot of that, and that should be legal. And that not only should it be legal, it should be criminal. But do we pass legislation to stop them from doing that? Do we understand how to lobby and put our resources together to ensure the integrity of what's going on in our community? Am I making sense?
Absolutely. Once again, anyone have any questions or comments? Type your questions in. We're at the halfway mark. We have a comment that just came in. All right, see. Trinity, Ambassador Trinity. Always read everything before you sign anything.
But you got to remember, sometimes when your back is against the wall and they saying you're gonna get out of jail, and this is the only way out, right? So we got to understand the circumstances that's involved, the scrutiny that's involved, the coercion that's involved. When you've been in jail for 16 years or
Yeah, that's real.
14
Yeah.
years, you'll sign anything to get out of there. So it's up to us who know better, do better, because we know that's a real thing. Most people gonna sign to get out.
Yeah.
I know I would. If I've been locked up and I was wrongfully accused for 17 years, and they gonna let me out, and they talking about we gonna let you out, but you gotta sign this. You think I'm worried about any of that?
Mm.
I've been locked up for something I didn't do for 17 years. Separated from my family, my children, my friends, my mama. You don't know if your mama on the individual mama on the sick bed or whatever. Daddy on the sick bed, children on the sick bed, you don't know. So it's up for us to start making sure, like Brother Raheem said, not waiting till the damage occurs, preventative measures. We want to neutralize these corrosions because it's systemically, it's across our community more than any other community. How many wrongful conviction cases we got to see? And 90% of them look like us.
We have something that just came in. Let's see. T Moody Ill 777. Wow, that is tough. T
Hey,
Moody Ill, do you have a question?
that's Empress Tamika. Peace and love, Empress.
All right. Peace and love. Is she in New York?
Yes, yes.
Is she gonna be? You gonna see you on Tamika? We're gonna see you on May 16th.
They have an event that day.
Oh, most 5 to 9
Yeah, they have an event that day.
in Harlem. 5 to 9. More Science Temple.
Yeah.
5 to 9. All right. Mm-hmm.
So it says prosecutorial misconduct. So we're going to talk about discovery. We're talking about the Brady rule or Brady discovery. This is common law. This is judge-made law. Requires disclosure of evidence favorable to the defendant. So prosecutors will hide information a lot of times. And if you're not aware of what's going on, you don't know, right? Then the prosecutors will abuse that power. This is how a lot of evidence gets suppressed because they're trying to get a conviction. They're trying to slam dunk a case that has been, let's say it was highly publicized, and they're trying to get a real conviction. So we're going to even talk about the O.J. Simpson case. From records that I seen, I watched something, and they said a man had confessed to killing Nicole. That they were aware that he made such a confession, but they were so adamant on getting O.J. Simpson, they never considered that. They thought the man might have been crazy. But come to find out, he knew certain details. But you don't hear that. So you got to remember this. The prison system is a business too. We can't look at that and say, oh, no, it's a business. And they packing people that look like me, you know, that speak Latin. They come from all over, right? All over the place because we was everywhere. And we the ones who are housing those beds. It's a business. So I want you guys to start thinking about it like this. This is what I was telling a friend of mine. We was talking about economics. I want y'all to look at it like this. You're supporting somebody, like it or not. You're going to support them or you're going to support us. Because you're going to pay your taxes. You're going to do all these things for a person that you don't see because you don't see, touch them, and smell them. You're doing all these things anyway, making it favorable for them. Let's create conditions for our community where they're favorable to us. We so predicated on things that it's not favorable to us. Buying things that's not favorable to us. Living places and doing things that's not favorable to us. Putting our money in places that's not favorable to us. See, when you look at treaties and you look at rights, when you look at contracts, you want to be in a contract that's favorable. Not disfavorable, favorable. The more favorable, the more what? Leverage. The more you have in a better place. It puts you in a better position. So I need you guys to start thinking about this information as like that. This is financial, and that this information of due process save us a lot of money and time, and that it bridges the gap.
You know what it is, King? Our people, because we were stripped, we lack the knowledge of national consciousness. So even though our people will say they're our people, they will say that, some won't say it, all right? But because the national consciousness is not there, you know, holidays and rituals and that which, you know, maintains that cohesiveness, right. Dance and clothing and national headdress and national festivals and, you know, that rituals and ceremonies and Chinese, that's China. So let me give a clear-cut example. All right. You know, you have even India, the dress and common language and, you know, traditions passed down and, you know, dance and traditional music and that, the language, festivals, passed down 500 years, 1,000 years. When a people stripped of that, understand that that's how that cohesiveness, it's called cultural identity, which maintains the national consciousness. Due to subjugation, which is an act of international law, France and Spain and Portugal and England, and maintained by the United States for over 200 years. That's stripping us of our national cultural identity and national consciousness. So This is why we don't work together. I'm explaining. This is it. This is it. That lack of knowledge of this. Well, why do Chinese work together? You know, why? I just explained. That's why. How they get together? That's why. It's because of that cultural identity. That's a strong bond. The language, which embodies the culture and the philosophy. Just dance and rituals and celebrations. That facilitates a strong national bond of a people. When a people are stripped of that, they're stripping away that strong. You're stripping the glue. You're stripping the glue. The glue is being stripped. So without that knowledge of the history, rituals, celebration, language, you know, because none of our people know that we've never experienced this. Those who are living today, so we can only talk it. That includes me. Like, we can only talk it. We can't say we lived it. None of us. None of us can say we lived it. Chinese can say it. Iranians can say it. Iraqis can say it. Japanese can say it. Burkinabes can say it. None of us can say that. None of us can. You'll be lying. You'll be lying. That's all. You should be lying because you can't say you lived it. When I talk about you taking an African American class, I'm not talking that. I'm not talking about taking no classes. I'm not talking that. I'm talking living it like the Iranians, raised in it, like the Chinese, Iranians, Iraqis, Indians, Burkinabes. You know, I'm talking that. So we don't know, we have never experienced that because it's been over 200 years. That matters. That's why. I just wanted to, bring that point in.
Yeah, that's a powerful point, Noble.
So we got to understand the importance of why the stripping is so important to be able to identify, because that takes you out of history, historical context. It takes you out of historical context of a people who were conscious, who was a part of a civilization, who sat at the table with other nations and negotiated. That of a stripping of that birthright, of that identity, of that right to be able to identify as that culture of people who had their own sovereign, their ability to control their own destiny, is within itself criminal under international law. But if you don't understand, right, these things, you cannot make the connection. So a lot of us is chasing the bag, but we should be chasing what's important, because I tell people all the time, it don't matter how much money you got when you can't protect it. We didn't have wealth before. Don't trick yourself and believe that people that they say of color didn't have wealth. No. When slavery ended, we were the labor force. We built everything. Not some of the things, everything. Agricultural, trains, everything. We did it all. Houses, masonry, paintings. We did it all because we was the laborers. So don't think we didn't come out of that. And I know you where you gonna go with it, Abdullah.
So I was going subjugation, the condition that which, and the condition by which we gained that, the condition that by which we did it all, as you said, the condition by which we gained, as you said, was in the subjugation.
Under international law.
Yeah, under subjugation. So yeah, so what you're saying, we did gain that, this, that, yeah, but under what condition did we excel, quote unquote? Under what condition did we, quote unquote, excel after, quote unquote, slavery?
Well, I wouldn't call it excelling because it was a time.
No, I'm just saying, no, whatever words, all right, I'm saying whatever words you used,
right?
Whatever words you use, I'm just saying, what develop, excel, gain, wealth, develop, grow, get the housing, whatever, Black Wall Street. Under what condition was Black Wall Street developed? Rosewood, Central Park, before it was Central Park. Under what condition did these quote unquote Black towns was established? Under what condition? Subjugation. They were not these quote unquote Black towns, 50 of them, whatever. They were not established under the condition or framework of reversion to sovereignty. They were established, all of them, under the condition of subjugation. I just wanted to put that out there.
And I want y'all to understand that when slavery ended, or before, slavery, our history didn't start before. Our history started way before slavery. So I don't want us to get caught up in that thought process either, saying that we excelled. No, we were excelling because we had universities, colleges, for university, medical centers. We were doing this way before.
Absolutely. There we go. Now we're cooking.
So we was people of prestige way. We wore silk. We had gold. We were doing this before other people thought about it. So we understood the sciences and everything. So our history start way, way before slavery.
And under what condition did we build that? And under what condition were we able to do that?
Under the legal framework of sovereignty.
There we go. Now we're cooking.
I got it, Abdullah. I got it. Yeah. So understanding the legal framework is very important. This is why you got to understand due process so you can trace everything. Is everything when we dealing with history, when we dealing with law, it's traceable. When somebody say, well, they don't have to prove what now. No. That's not how law works. Everybody is on equal footing according to law. Justice is supposed to be blind. So we need to understand these things. And if you don't know how to identify it and understand what's going on, who is supposed to identify it? Who's supposed to help us? Because they sure ain't going to help us. This is why these legal tools is very important to understanding how to navigate and look at the law and be able to assess it to promote change. We have to start collectively working together in unison as a chain, wrapping around the injustice until it is suffocated in all forms. Administratively, a lot of us don't know how to deal with these administrative issues, dealing with these administrative agencies that's contracted with government. We don't know how to deal with those people. We don't know how to put things into place, contacting the inspector general to inspect what these institutions are doing, and then formulating a body or institution that is constantly up on all institutions that have their hand and being able to examine these things, these unethical practices that a lot of these agencies do. and be able to file certain lawsuits when it's necessary as a class action because they're affecting our entire community. Hold on 1 second.
Now, the love for self,
I was
loving
just about to
ourselves
say
is
so.
the answer. How is that facilitated? I'm talking about as a people, though, not
As an individual, no.
individual. Now, we're not talking individual. I'm not talking. We're not. All right, that's a context. Context. We're not talking. I love King, or I love myself. We're not talking that. I'm a love. No, in order the love we talk about love ourselves. Would that be in the framework of national consciousness? So let's put the framework there. The love ourselves as a people can only be restored from a national framework perspective through what? Restoring the knowledge of our history, festivals, rituals, ceremonies, headdresses, clothing, holidays, language. We're talking about raising a people who's been subjugated, who's been stripped of that, because that's what culture does. Look at the flyers. Flyer that you see that go up that Raheem and I wear on the flyer, having the flyer. Ooh. Whoa. You mean that's us? Whoa. We built what? Whoa. That wouldn't facilitate love? But y'all came from monkeys. Y'all ain't done nothing. You see in the textbooks. You see in the textbooks. People that look like Donald Trump in the textbooks. They what? They're at the what? House. They're at the what? You see, what's that picture? 1776. Help me out. The Independence Hall. Independence Hall. Drafting. You see us being whipped in the textbooks. Hosed down. Chained. What does that do? All right, what does that do for them when they see Thomas Jefferson, Alexander Hamilton, drafting? What does that do for them? Psychically. What does that do for us? Whip. They know what they're doing. And we're talking about it at a young age. You're talking about 3-4 years old in the schools.
They start the conditioning early.
So you got Europeans and us in the same classroom. So let's say you have a classroom of 30. 30 of them, 30 of us in the classroom. We're in kindergarten. 30 of them, 30 of us in the classroom. Children, open your books. Today we're going to talk about the Declaration of Independence. And they show pictures of all of them. I mean, how they then the next day, today, children, we're going to talk about slavery. Who they going to show in the textbooks? Wearing what? being what and chains what? 30 of them, 30 of us. This is real talk. This is real. All right, go ahead, King. I just wanted to address that love ourselves comment.
Okay, let's get back to the. So we talk about discovery, right? And when we're looking at discovery, what do we need to be thinking about? So this is evidence. Requires disclosure of evidence favorable to the defendant. Okay, so what you must understand. Prosecutor controls the evidence, the witnesses, and the charges. That power can be abused. What did Carmilla Harris say, Abdul? Remember that
She
video?
said, Kamala Harris, when she was attorney, what's it called? She was attorney general or district attorney.
District attorney.
She was district attorney, and she was being interviewed. She was at Google University. She was at Google University, and she was being interviewed. And it was like an hour-long interview or so. And during the course of the interview, she had made a statement that even when she was a prosecutor, that she would talk about the pen. With a pen, talking about the power of her pen, the power of her pen, with the power of my pen. All right, I can charge someone with a felony or something like that, right? And they would have to do what? Take off work. Go down to the courthouse, take off work, go down to the courthouse. They would have to hire an attorney. They would have to be embarrassed by their community. You know what I mean? Talking about with the power of the pen. And then later on I'll drop it to a misdemeanor.
No, she said altogether 2 weeks later I could just drop the case.
I could drop the case, yes. Yes, she did. All right, thank you.
So you got to understand what kind of power that holds in that position. That's not a power to be looked at lightly. So when looking and examining this, we got to know due process. We're gonna get into equal protection at another time. That's another lecture and discussion. But I need y'all to understand what due process from a procedural and substantive point look like. I need you to do your homework and study these things so that you can start being able to recognize these issues, right, sooner than later. When you're in the courtroom, you know how to identify this at the drop of a dime. The judge over talking you, because they do that all the time. The judge be talking, and then you be waiting on something to say. I raise my hand. The judge like, put your hand down. What? Then I'll be like, objection, Your Honor. What you objected to? Your Honor, you doing a lot of talking. I didn't try to say something. I'm not being heard on my motions. Is you gonna give me a right time to be heard on my motions? They don't even give you time to. I didn't have the judge tell me no. Told me she wasn't gonna give me a right to be heard. I had to tell her I'm gonna see you in federal court for civil rights violation. I said, okay, you bad. Let's see how bad you is. You better hope I don't know the law as good as you keep telling I don't. She held me, told the bailiff if I leave, I'm going to jail, and then turned around and granted my motion and granted my action and gave me my relief because I had the wherewithal, because she didn't want to deal with that. Because it was on record. It's on camera. Her saying, nah, I ain't giving you a right to be heard. Oh, you bad. Black lady too. Oh, you bad. You See, unconscious more, you bad. Go on with your bad self. But because I was able to identify these issues, she said, don't let him leave. She kicked me out the courtroom. But she told him, do not let him leave. I told her, I see you. I'm filing this 1983 against you. Don't worry about it. I see you in federal court. See, so stop him. The bailiff's like, I'm like, man, she just kicked me out. I'm about to go out now. They told me no. I'm just standing out there. They're sitting for about 30 minutes. Then she called me back in. So, but if I wasn't astute at understanding what was going on, guess what would have happened? She wouldn't have took me serious. She knew I knew something. This is where we got to be, family. It's no more ignorance of the law is an excuse for none of us in our community. There must be people who understand this stuff well enough, but we can walk around this, regurgitating this all day. Our children need to know this. There need to be pools of our children who know this. Let's get back to the lesson. So let's look at this, right? Scenario. The prosecutor has a video showing you were not present. They do not give it to you. You are convicted. This violates the principle of fair trial again. Element. Disclosure of exculpatory evidence. Exculpatory evidence. Evidence. Video exists, not disclosed. Findings of fact. State withheld favorable information or evidence. Conclusion of law. Conviction invalid. New trial or dismissal. 9 times out of 10, you're going to ask for dismissal. Because you cannot break the law to enforce it. If the truth is hidden, the verdict is corrupted. So I go into, let's go down here. Practical tools. Motion to compel evidence in this situation. Motion to dismiss. Motion for sanctions. And motion for new trial. These are things that you guys got to understand how to do. This is pretty long. I'm trying to get some down. Because this is just the first part. I got how to read statutes, final closing. Let me go through this because it's a lot.
We got 28 minutes. You got time, brother. Let's do a couple more, brother.
I'm going to do so. It's part 4. Why learn the rules of the court? Details. Ohio rules of criminal procedure, Ohio rules of evidence. The court only respect what is properly presented. Right? You got to know the rules. So the court only respects what is properly presented in accordance to the rules. You have to. You bring a document to the court, evidence rejected. It says, but not authenticated. No witness, no foundation. Right? It's not supported. You don't have nothing. Judge excluded. What is the formula? Principle. Admissibility. It's admissible. It wasn't authenticated. No proof. Document is real. So, what do I mean by authenticated? So, when we talk about evidence or affidavits, a lot of times they will present information or you will present information that has no supporting facts. So you might motion the court for something and then put in the maybe use an affidavit in support of the motion. That's what I do. Most of us don't do that. And then I have the exhibits. You want to have the affidavit as the anchor. You're going to put in the motion asking for that, and you're going to have the supporting thing, which is the affidavit, along with the exhibits to support everything. It's a trifecta. So now when the court look at it, they looking at the memorandum of law and the request according to the rules that you're asking that, and you might have it supported even by case law, further strengthening it. Then you might have an affidavit to support everything that you're saying based on firsthand knowledge, and then the exhibits that support that firsthand knowledge with the affidavit. Teaching line, good evidence used incorrectly becomes useless. I'm going to say that again. Good evidence used incorrectly becomes useless. If you don't know, if you don't follow the rules and you present evidence and you don't have it the way the court required and it get rejected because you didn't take the time to know it, what the rules were, don't matter how good of evidence that you got, you don't know how to present it. Now it's used correctly. It's useless. Another missed deadline. You file a motion late outside of the scope of the rules. The court denies it automatically. Timing is not technical, it's jurisdictional. You got to understand these things.
Read that again.
Timing is not technical, it's jurisdictional.
Explain that.
So the rules give you a timeline to file within that, within the scope of the jurisdiction that you're in. Because each set of rules sometimes are within the boundaries of a particular jurisdiction, and the judge have the discretion to make a ruling according to that. Especially if you don't give good cause showing why the delay, which they could call it excusable neglect if you don't know the law, because you didn't have enough wherewithal or you don't know the rules on how to apply what your actions is, right? Now, the court saying, hey, you filed outside of the law. That's jurisdictional. It's not technical because technicality deal with precision and articulation and all of those different things, those elements to creating or drafting what you need. And the court can overlook technical issues. That's why I told you about Turner versus Kerner versus Turner. Kearns versus Turner. Because they can't scrutinize you as technical as an attorney if you understand the law. So it becomes a jurisdictional issue when you're outside of the rules, and it becomes the judge have the discretion to rule on that when you fail to adhere to timely doing things. So let's talk about the role of the judge.
Hey, hold on, King. Real quick, can you address this comment?
Yeah, there's a question there. Mm-hmm.
All right.
You want me to
question,
read it?
Yeah, read it, please. Thank you.
All right. It says, add by Goods and 4Ts 8356 as aren't Asiatic who know the law are not supposed to be in those lower courts that is not respecting the law but doing colorable legal witchcraft on those don't know any form of civil law.
Mm. Abdullah, why you be setting me up, man? Why you setting me up?
It's
That's
on
what
there.
they
I
put.
can't just
That's
let
what
that
they.
be on there and you
Yeah.
don't address. We don't address it.
So this is what I'm saying. Another misconceptions. Thank you, brother, for just. I want to honor you for sharing it, right? Because it takes courage to share your thoughts, especially on a live platform. So I don't mean no disrespect, but that's a misconception, and I need us to raise up to this level of information because we go in there with that mentality, and what happens is that we end up finding ourselves in a pickle because we don't know the law. And what happens is you end up getting convicted, you end up getting contempt, and you, due to the fact that you're going back and forth with the judge, and the judge is not. That's why I was about to go over the role of the prosecutor and the judge, and it's just that we get stuck in these misconceptions, and a lot of people are teaching this because you won't get a remedy out of it. A lot of brothers say they do, but they have to show me how they got remedy using this methodology. Most brothers or a lot of groups are being dismantled because of these concepts. A lot of these groups' methodology is not working because they're not technically proficient. They don't know the law and they don't understand how to address it. We do it all the way to the highest form, all the way up to the international level, so we understand the legal framework that's in concise and uniform with the various jurisdictions within American United States American jurisprudence, so that we can speak accurately. You know, I'm not just speaking out my butt. This is I've been litigating for a long time. I've been doing this for 17 years. I didn't seen a lot of Moors with their practices, and they get themselves in trouble because they act like they above the law. They act like they know how this stuff works, and they don't. Based on these comments, based on the information that they're presenting, I do not wish you go to whoever group you with, brother, who's teaching these methodologies. You need to sit back, and I need you to do this. Evaluate what you're listening to. Have them show you where this works. I ain't talking about no, um, man, it worked. Come here, brother, tell him it worked. No, 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 no. Have them show you exactly court cases that they have been a part of and that they was exonerated or somebody was uh, acquitted, right, from a case based on using these formalities. Please, brother, hear me. I do not wish you any harm. I wish you nothing but the best in your endeavors. But please, I need you to analyze what you're doing with certain people because a lot of people have went to jail and some even may have lost their life behind this information. Nephew, I'm doing a podcast.
Right.
So I'm just very critical when misinformation is out there. They're telling y'all status correction, all of these different processes, and it has no recognition in the law. The law don't recognize it. And you talking about you're not going to court to due to these, these civil law courts that you only in federal court. Um, please don't get yourself in no trouble trying to utilize this information incorrectly based on teachings that somebody misled you to believe. Believe me, I have a lot of experience. See, I could talk on record because I work with Abdullah. We did a live video and we talked with a brother, and I showed and proved that the information worked. right? We showed and proved how the information worked. Not know nothing. We talked about it. I said this case is already won. Did I say that, Abdul?
Yep. Yes, you did.
And the verdict came back no prosecute.
Yep. No low prosecute.
No late prosecute.
Yeah.
Prosecute.
Mm. So let me ask this, right? So since you've been doing litigations for so many years and you've most likely seen a lot. So what do you say to these Moors, or people who say, "Oh, I got remedy. I went in there and I got remedy. I won my case," but because I know
Show
just
me.
having conversations with you in the prior times, you was telling
Show
me
me.
that a lot of these, pardon, 1 second, a lot of these courts and judges, they just push the case out because they don't really want to deal with it. So I wanted you to touch a little bit on that.
So sometimes if it's not something of importance, the courts, because they have so much going on, right? The judges just let it go. Especially if the judges feel like it's time for him to get up out of there. He retiring. He at the end of the day, he at the end of his ropes. If it ain't really no real big issue, he'd be like, okay, let it go. And a lot of Moors would think that as a victory. And they ain't get acquitted. The judge just said, okay, we dismiss it. And the prosecutor don't, sometimes they agree or they'll talk. He'd be like, man, let's dismiss this. We got too much of a caseload. We got too much stuff going on. We don't have time to deal with this shenanigan because they got to give you due process. They can't just say, oh no, you got a right to be heard on everything, even if you said dogs was flying over the courthouse. You seen some flying pigs and dogs kissing outside. And you said that's why I did it, Your Honor. Whatever the scenario the court has, they have to afford you due process to be heard. So sometimes the court don't want to be bothered with it. They just don't. And sometimes they say we're gonna dismiss this because it's not nothing of that significant of importance. But going there with some foolishness for real, you mess around, get a contempt, you mess around, go to jail. Especially if you're dealing with a judge who's ready for war, who's ready for action. Find yourself in there getting you some action. You're in there, and so what I try to tell people: show me over and over and over how you beat your case. Because if you did it once, you could do it twice. If you did it twice, you can do it 3 times. If you did it 3 times, you can do it 4 times. Show me. I said, show me. I use Crenshaw versus the United States for the nature of cause of the action that the court need to identify the nature of the action by its jurisdiction, specifically the jurisdiction that we're in. The court cannot identify that if the prosecutor. This is not on the judge. This is for the prosecutor. Prosecutor failed to identify the jurisdiction according to the constitutional elements based on the Sixth Amendment that Crenshaw versus United States identified that the nature, the cause of the action must be identified. Tell me this only for a jurisdiction within the boundaries of the jurisdiction of the Constitution. Please identify the jurisdiction that this court is utilizing or this action is being brought under. Because there's no mention of no civil nothing in the United States Constitution. It doesn't say there's no civil court. It says inferior court. So what do that mean? What is this court? Okay, I understand that this is traffic court, but what action? I know you're bringing under the cause of action. I'm not talking about the cause. I'm talking about the nature. There's only 4 of them. You identify them: common law, equity, maritime, and admiralty. Which one is this court utilizing on the Constitution to bring such action? They might tell you it's quasi this or quasi no. It don't say nothing about no quasi constitutionally. I'm asking the constitutional jurisdiction that's being identified. Constitutionally, this is a constitutional question for the Supreme Court to answer. Because this violates my due process, because the court is hiding the jurisdiction in which I'm unaware of. And I have a right to understand, because now I have to look at the Constitution and the elements that's involved under the state statute, which is being utilized. I need the court to help me understand this. And I'm also asking for discovery material based on the statute. What is the intent and purpose of the statute dealing with the elements, so that I can properly identify this? The court may say, well, that's your job. Well, I'm asking the prosecutor to understand the intent and purposes so everybody can understand if he's bringing the action within the scope. Did he meet all the elements? I'm presenting a legal defense, because this could be a frivolous act in which the state is using taxpayers' dollars to hold me up in this courtroom, which violate my fundamental right to work, my liberties, to work and take care of my family. I'm missing a day of pay, Your Honor. Not only that, he's wasting my time and taxpayer dollars, which I am a taxpayer. These are my fundamental rights that's being violated. On top of that, that's other substantive issues that I can raise to the appellate court in the form of an injunction. I'm asking this court to please help me identify and do its due diligence to ask the prosecutor to identify these things. These are due process. These are all due process. I'm not coming nowhere. Everything I'm talking about, you can go find. You can go look up. I ain't make up nothing. All of this stuff is already historical text. All the stuff that I'm talking about, common law, right to be heard, this is historical text.
And King, we got it. The person has another comment. Raheem, want to read that so we can.
1 second. Buy goods and Forties 8356 again. How will every go up in a mock court that truly really on the lower level is only just a bank going under the codified as a SO hyphen X? Let me repeat that again. How will every go up in a mock court that truly really on the lower level is only just a bank going under the codified as a SOX hyphen X? I will ask that you ask that question with a little more clarity if possible.
So does King understand?
I heard him say, well, do you understand, King?
So this is what a lot of the people are utilizing, saying that the court is a bank as it relates to the Federal Reserve, as under these banking laws that but they're misconstruing this information to the degree where they make it all about banking, right? So we understand that the court is a business, and we understand that all businesses is technically fall in some category of banking. But under this, we're talking about the rules. We're not talking about the institution in itself. We're talking about the rules that's being applied. We're talking about rules of the court that directly affect the outcome of the case, not all of these different things associated with the banking, because they have nothing to do with the facts. They have nothing to do with the common law. They have nothing to do with the statute. They have nothing to do with the. If we go down everything, understanding, you know, the different levels. So we understand the philosophy, the principle, the evidentiary standards of practice. So we're talking about the rules of evidence and everything, all the rules that apply. We're not talking about any banking laws because the banking laws only gonna come in with what?
Hey King, what they're doing, I know what it is. This is all right. This is what they was taught. This I know. I know. This is what the person, and this is what's been taught. This is what European freedmen groups teach.
Right,
What they teach is as a way to challenge jurisdiction. That's where that's coming from.
right,
The court is a bank,
right.
so it's not legitimate. They're not taught what you're teaching. This is they're not taught. This is not the teaching. This is not taught. So they're not going to come with rules of the court, and because what's taught is the court is a bank. You know, the judge bench. You know what I mean? Means bank, and you know, so they're coming from that perspective to challenge. That's the way. This is what this taught. This is what they're taught. You know.
But
So there's this. No. I'm just saying. What you're saying is correct. This was coming from a clear up on
right.
how this is the teachings out there. All right. No, what you're teaching is not the teachings. What you're
Right.
teaching is not the teachings out there.
Because that's all they're going to do. They're going to talk about, oh, we deal with this on this level, dealing with the. But that's after. All of these things that they're talking about, that's dealing with the money. That has nothing to do with the actual case. That's outside of the scope. They don't even understand how to look at the legal framework and apply it in a proper perspective. That has nothing to do with the case itself. They're going to make it about the case because this is what. So I challenge all these people, give me the remedy. Because if I got the remedy, because I showed you the remedy, didn't I show you the remedy, Abdullah? Didn't I show you I can understand how to deal with
No,
it?
yeah, you actually should. You presenting remedy. You be so someone has it. Someone is charged. Someone is charged with a crime. All right.
So I showed
Let's give an example. So how would they are they all right? So they would come. It's a bank. It's a bank. I mean, all right. So someone is charged with a crime. So what remedy will that person who's asking the question give someone who's charged with carrying a firearm, an unlicensed firearm? Someone is charged with burglary. Someone is charged with we talking real talk. So what remedy? How would that person? Would they say to tell the person to say go in there and say the court is a bank? I mean, what this? That's why I'll just give actual scenarios that go on every day in our community. How would they address these these allegations? How to address the charge of a felony or misdemeanor? Real talk, real time.
So I want to say this, right? Make this real quick because we got 2 minutes. Because I didn't even go over the prosecutor's role and the judge's role, the role of the judge. The judge, those banking laws and all that stuff are mute in that courtroom. They cannot be applicable. They can't even be applied. They will not entertain it. They will not. They don't have the jurisdiction to entertain those banking laws or whatever they're going to say they do because it's not explicit to them. This is why I keep talking about the legal framework. They're talking something outside of the framework of the court. The court. So who wrote those rules? The Supreme Court wrote those rules The state Supreme Court wrote those rules. They have jurisdiction over all those civil rules. So they examine those rules with scrutiny because they wrote them. Statutes are written by what? Legislation. They get to judge and see if the legislators conform with the Constitution. Is the statute and is in compliance with the Constitution? Did it violate any constitutional principle? The stuff that they're talking about, you can't even touch.
What I'm saying, King, they are charged with a felony. Are they going to show me? Send my phone number is 215-300-5471. My email is etymologyvocabulary at gmail.com. Send me, King, send me that you use this. Let's talk real time. Send us, show us you got a remedy using this. It's wordplay or a cash register. Show us. That's all I want. I don't do the back and forth. King doesn't do the back and forth. We don't do the back and forth. That's why King does. We're not doing the back and forth. King says, show us. That's it. Show us you got a remedy doing this. That's all.
I don't want to see no paperwork that you concocted. We need to see where it came from a legitimate.
Right, because gave
you that remedy. A sanctioning body who has the authority to give out that remedy. We ain't talking about, well, I wrote this and you see this, brother, because I see a lot of Moors doing that too. They show motions that they filed and say they got remedy. They didn't get because it wasn't no orders. There wasn't nothing signed out by a judge or an official who has the authority and the capacity to make such decision-making process. So I don't believe it. See, we got proof where there was orders that was by a judge signing off. These are things that's provable. We're not going from that. I'm not like, I don't hear it. Well, they're not going to tell you this. You can't prove it. They just
they're not going to tell you. Silence is acquiescence. They didn't respond. They just left it like that.
We ain't doing. I didn't see where they left a case in limbo and the court didn't have jurisdiction. It was still in the appealing court jurisdiction, but not what they're talking about. No. I've been down this road too many times. I done heard every angle, every remedy, all the different things. I've been doing this for 17 years. I came to one conclusion. You better know these steps that I'm talking about, or you're going to find yourself in a pickle.
There we go.
Well, like Abdullah said, show us, you know.
Exactly.
You did a case live and beat it. Show us.
Yeah, sure did. All right, y'all. All right, so that's all she wrote. I thank y'all for Brother King. You did an excellent job. Ambassador Rahim Al-Bey. Always. I'm looking forward to seeing y'all on May 15th. May 15th. All right. And you know the lectures on May 16th. Rahim, hit it again.
Learning legal tools to protect, safeguard communities. May 16th, 2026. Doors open at 11:30 a.m. Eastern Standard Time. 122-13 Guy Brewer Boulevard, Jamaica, New York. 11436. Contact me for tickets. They're $25. Seats are limited, so I suggest everyone start getting their tickets now. My number is 347-832-9875. Again, 347-832-9875. Contact me for any information for tickets. My email address is rab.greatseal7@gmail.com. rab.greatseal7@gmail.com.
The number seven.
Number 7, yes, the number 7, pardon. Gratitude.
All right. So thank y'all again. We have to go. I mean, how do you handle an injustice when the courts have denied me all access to due process and they have documented it? Look at this video again. Just look at the video. All right, he's answered that you have to deny you due process. So how to handle that? Look at this video. We have some other videos too. Take my number 215-300-5471. 215-300-5471. I'll sing some other King's videos that we did on this platform and other platforms. Mike's case. I'll send you the 2 videos that we did on Michael Long's Bay's case with all the exhibits, the whole process, the whole explanation. All right. Yes, we have that. All right. So you lack knowledge. That's all. You lack knowledge of due process. You lack knowledge of legal procedures. Just lack knowledge. That's all. All right. So we here. All right. 215-300-5471. We'll take care of you. All right. See y'all on 15th, y'all. 16th. King, we live and direct. Peace, everyone.
Peace and love, everyone.
Peace, brothers.
Peace. He's still, you know what? That's so we're going to end. All right. So he got a peace. Good.
Peace.
Peace.
Peace.